Hi, my name is Dan Alkire, and today I will be talking about due diligence, private placement memorandum, private placement offerings, term sheets, and regulations that go with private placement. I'm going to start with due diligence because I think it's a topical not only to private placement but also to business and finance in general. It's a common sense approach to researching and evaluating a business opportunity. And I think with the use of resources, due diligence can be practiced there as well. Being conservative with resources, choosing the right ones, using them carefully. Due diligence reduces risk and mitigates losses, and it spans investigation into all relevant aspects of the past, present, and predictable future of a firm. Now, it's useful for evaluating assets, defining representations and warranties, and or negotiating price concessions. But it's also a good way to make sure that one is compliant with laws and regulations regarding a business and their dealings. It's a two-way street, so in as much as investors are researching deeply into a business opportunity or a firm, the firm should also be doing that of the investors so that everybody knows as much as possible about each other. Due diligence can be done by lead and co-investors, corporate development staff, attorneys, accountants, investment bankers, loan officers, and other professionals. Now, due diligence starts when there's a possibility of a deal, but long before anything is signed or anything is under contract. Now, the costs, the time constraints, the commitment to the deal, and other factors are going to determine the effectiveness of due diligence. So it can be very costly. It could take a great deal of time, but the commitment to a deal and the time constraints are going to be dictated by the parties involved. Now, with a private placement offering, a firm is seeking financing from outside investors, and they may opt to use a PPO as an alternative to other equity or debt financing. It's an alternative to selling stock in an IPO, and it's another way of financing other than borrowing from a bank. It's easier, faster, and economical for the entrepreneur. Now, these securities have not been registered with the SEC or the Securities and Exchange Commission, so that is one difference in a PPO. A PPO is exempt from some state and federal laws. There are laws and regulations that are in place to protect investors, and that may not necessarily be the case in a PPO, so everybody does need to be careful. And some rules within federal regulations that limit the amount of money that can be raised in a PPO. Now, the securities involved may be stock, common stock, preferred stock, limited partnership interests, membership interest in an LLC or limited liability company, or an investment in a product such as a note or a bond. A private placement offering can go a long way in saving time and money for an entrepreneur. Some of the drawbacks or the speed bumps in a PPO could be finding enough attractive investors. Can be very costly and time consuming. Securities can be sold much cheaper in a PPO than in an IPO, so there may be some capital loss there, and an entrepreneur may have to relinquish a little bit more equity to make up or compensate for the risk that the investors are taking. This is all drawn up in a private placement memorandum. It's a legal document that includes details of the securities, value of the offering, the risk involved. The information offered in this document helps the investor make a sound judgment about the merits or the demerits of the deal. A PPM is an offer to contract with investors. It is meant to be persuasive, it is not meant to be persuasive, it is meant to be descriptive. And the scope and purpose of the PPM is not to market the company, it is to attract investors. So it is not a business plan, although there is some overlap between what a PPM does and what a business plan does, but whatever the business plan intent is, you wouldn't find in a PPM. It's not a marketing tool or a sales pitch. It's meant to be a transparent document to fully inform potential investors of the firm. It includes an introduction, summary of the offering terms, risk factors, management and company description, how the proceeds are going to be used, securities description, and a subscription to procedures in the exhibits. Some of the disclosures include the type and class of the securities that are going to be offered, the rights and privileges such as voting rights to the securities, conversion and liquidation of the shares in case anything happens with the firm, how many offerings there have been or there will be, the minimum and maximum number of shares that are going to be offered, the share offering price, how much the company is paying commission on the offer, and what their net proceeds are going to be. It can also detail to whom the offer is being presented, complex and legal terms that are meant to protect the entrepreneur, the risk to the investor, and how the funds are going to be used. It's a complex and legal document, so accuracy and completeness is very important, and it can be created by skilled or experienced attorneys, investment banks, as well as private placement memorandum specialists. Now, as far as regulations go, there's a few regulations that govern PPO, but Reg D is the biggest one, so I'll be speaking to that. It has separate exemptions for $1 million, raising money up to $1 million, $5 million, and unlimited amounts of money. There are 6 rules in Regulation D. 501 covers the definitions of the various terms. Rule 502 sets the conditions, limitations, and information requirements. 504, 505, and 506 pertain to how much money is going to be raised and to whom the offer is being made, and then 503 contains the disclosure requirements. So Rule 504 is for sales up to $1 million in securities. Securities are issued and are restricted, meaning they are difficult to resell and are subject to certain controls, but there's no restriction to the number of investors involved. Rule 505 pertains to sales up to $5 million in securities. No restriction on the number of accredited investors, but a limit to 35 unaccredited investors. Rule 506, there's no limit to the sale of the securities, so no dollar amount is limited. No restriction to the number of accredited investors again, but a limit of 35 unaccredited investors. However, those unaccredited investors must be sophisticated, so they must have background or experience in finance or investments. That brings us to the term sheet. It's a printed agreement between a company and its investors. It's a defined document, but not technically legally binding, at least in the beginning. It describes the conditions of the partnership and who's responsible for what financially and legally. And it includes the valuation of the company, the price per share of the investment, and the economic rights on the new shares. Elements of the term sheet include valuation. Probably one of the most important ones is the value of the company. Financing, are they debt financing, equity financing, or both? An option pool. The investors want an option pool so that their new shares are not diluted. Liquidation, so if worse comes to worse, what are their liquidation rights? Participation rights. Do they get to enjoy the benefits of the sales of preferred stock as well as the sales of common stock? Conditions to close, dividends. Are the dividends paid? Are they accrued? Are they not accrued? Anti-dilution clauses, control, which includes the board of directors, the makeup of the board, how many seats, who's the CEO, etc. And exclusivity, which means that the investors want to make sure that the company is exclusively dealing with them and not trying to pitch or sell to other investors. So that is my presentation on the due diligence, private placement offerings, private placement memorandum, term sheets, and the regulations governing them. Thank you.